I'm now going to ask each of the speakers to introduce themselves and give some a very brief CV. Would you like to start?
Yeah, sure. Should I have them up?
Yes.
Hello, everyone. My name is Leima Daudzai. I am a trainee solicitor at Adams and Reimers. I completed my undergraduate degree in Dubai, and then I subsequently did the GDL and LPC at City University, so I am a City graduate as well. At Adams and Reimers, we are a legal 500 firm, and we have a base in London at Lincoln's Inn Field and also in Sussex.
Hi everyone, so my name is Matthias Chen and I come from Acton Chambers. I'm a practicing commercial barrister. I was called to the bar in 2015, right after I finished the bar, well back in the days it was called the BPTC and now it's called the BPC, the bar course effectively at City Law School. So I too am an alumnus of City Law School. Before then, I started off uni as an LLB student in King's College London. So just a bit further down the road, and then I went over to Oxford to do my master's, and it's called the BCL, and that was before I came over to City Law School to do my bar school, and then right after that I've started off as a pupil at Acton Chambers, and been practicing there since 2016 for the past 6-7 years. We do mostly, all sorts of commercial litigation, but mostly construction, infrastructure, and energy disputes, and in particular we do quite a lot of international arbitrations as well in addition to litigation.
Good afternoon everyone, my name is Jayesh. I'm one of the partners at a law firm called Quastels LLP, and we're a full service practice. I look after our immigration and corporate immigration teams, and in terms of educational background, I was at BPP for my undergraduate and for my master's and LPC. The firm's really focused on being a boutique practice, so I guess the commercial awareness aspect is really important for us. And our firm is very much not siloed, so it's very common for some of our work to bleed into other areas of our practice.
Hi everybody, my name is Ranjit Sond. I'm a solicitor at the Government Legal Department. I specialise in litigation and inquest work. But prior to my life at GLD, I was in private practice and I used to do claim PI for about 20 years. I'm from East London and I trained at a local firm in Canning Town, which sadly isn't there anymore, but so that's my day job, but I'm also president of the Society of Asian Lawyers, which is a UK organisation representing the interests of Asian lawyers in the UK. We're currently working with the SRA on some research about gender equality pay gap, but and work like that. But so a lot going on in the background as well. That's me for now.
Hello, my name's Miranda Growell. I'm a barrister and a fellow East Londoner. And I was a student of Sarah. She taught me EU law many moons ago when I did the GDL full-time between 2009 and graduated from that in 2010. And then I did my BPTC at the other City Law School campus, graduating, being called to the bar in 2014. I went to the bar late when I was 30. I'd had other careers before, which I can talk about, but this is a second career for me, maybe a third career. I'm a common law barrister, meaning I do a bit of everything, from inquiries, which are very lucrative, to the other end of the scale, which is as a legal aid lawyer, which is where my heart is. So the other stuff, the lucrative stuff, funds, the poor law, where I'm happiest, and I'm doing a lot of civil. I would love to do crime, a lot more in criminal defence, and I do some. But as all of you know, and we are talking about commercial awareness, you can't develop a whole career in crime at the moment. It might change for you guys when you graduate, but it's quite difficult. So I'm predominantly a civil barrister, employment, housing, a bit of family. I know some of you want to do family, but that's all I'll say. But we'll talk a bit further. So that's me, and it's great to be here. Thank you.
Does anyone already have a burning question, or would you like me to kick off the questions? Okay, I'll ask the first question, and then maybe one of you or a few of you will ask some subsequent questions. It occurred to me that commercial awareness is quite a subjective term. So I'd like to ask each of the speakers to say in a minute or two how they might define the term commercial awareness. Can I start with you?
Yeah, I agree in that commercial awareness, ever since I started my legal career, was one of those buzzwords that everybody talks about, but nobody really knows what it means, especially at the beginning of your career. To me, commercial awareness is just as important to think about the why rather than just the how to develop it. We work in completely different industries, just us panelists here, we're all working in different industries. It's very important to understand the industry that your clients are working in, so that when you provide them with advice, that advice is backed by actual knowledge of the industry that they work in. It's not just legal. So it's the foundation of legal advice, commercial awareness, to be aware of what's going on in the world, what are the current events, and how, and to have the ability to analyze that and understand how that affects the clients and the sectors that your clients work in, and even more a step further, what type of risks that those events could give rise to that might affect your clients, and then how can you work with your client to mitigate those risks.
Right. Can't say I'm going to improve on that very much, but I can tell you sort of from a dispute resolution point of view, sort of what commercial awareness normally means, particularly if you're practicing as a barrister. And I think it's, in a commercial awareness is, again, one of those things which are probably easier to recognize than to define. You sort of know it when you see it. But essentially, if you think about the context of sort of resolving disputes and helping your client basically to achieve a particular result in, let's say, litigation or an arbitration or maybe mediation, commercial awareness comes into play, first of all, in terms of the choice of, well, what sort of forum would you want to resolve your disputes and how you want to resolve it, how much cost you want to throw into this dispute, for example. That's the sort of thing that you would think about first. And then secondly, in terms of how you frame your client's case and, you know, what sort of results you want to get them to. And that is very much informed by, of course, their commercial objectives as a business, if you're acting for a company, for example. And just putting that into context, for example, if sort of from my point of view, you know, working in construction disputes, energy disputes and all that, if you have a dispute about, let's say, defects or delay, you know, you may have, you know, the most solid legal case, evidentially or legally, it doesn't quite matter. You may have the best case ever, but, you know, if the cost that you're going to spend on resolving that dispute and the sort of result you get to is just going to completely torpedo your client's company because, you know, they're not solvent, for example, or it might damage their commercial relationship with an existing client of theirs, then, you know, you have to sort of think twice about, okay, well, what is the best strategy going forward? How do you want to resolve this dispute? Is it better to go to an arbitration, or is it better to resolve it confidentially, amicably in a mediation? So that's the sort of thing. It's always thinking about what your client wants to achieve commercially, thinking ahead in terms of the future and sort of how you move away from the dispute after you've finished that sort of whole dispute resolution process, and not just about, you know, what is the legally right answer or what is the merits of the case. That's, in a way, sort of by the by from the client's perspective, I think.
I think it's going to get gradually more difficult to top the answers as we go, but
I can ask you another question if you like.
I could touch on it slightly.
Otherwise, I can ask you another question.
Sure, I'm happy to give a little bit on this. I think as much as it being about just, you know, the client and so on, it's also commercial awareness is really important to sort of bring empathy to your client's case and to for them to understand that you know their industry as well as they know it. Besides knowing the law, I think that's something that we all are on our journey to or trying to achieve, but trying to place yourself in their shoes and trying to make decisions or help them to make decisions according to the world at large and the affairs that are going on globally. So my sort of side of work is in relation to immigration, and there's been a lot of changes with Brexit and post-pandemic, and we've had to react to sort of the worldwide climate as a result. So I think that's really important, and I guess commercial awareness from your perspective as lawyers is subjectively who you know and your connections and how you can bring that into the room and sort of create some resonance with an individual or a client.
I will say a few words because I come at it from a slightly different perspective because I work, it's in effect an in-house legal department for the government in lots of ways. So commercial awareness in my context, in my daily work, isn't so much private clients, but it's more the kind of government departments, what their objectives are. And we have to operate with a duty of candour, so we need to be honest and open and transparent wherever we can be. So it's a slightly different take on it in my line of work, in that you need to be aware of your client's needs and perspective and objective, because we're trying to advise the government to govern well within the rule of law. That's what our aim is. But it's knowing and being aware of all different departments which sometimes interact and overlap, and knowing that there's always public scrutiny pretty much no matter what we do. So it's always having that in the back of our mind as well, or the forefront of our mind really. So it's slightly different, but that's what it means to me. But generally, because I've spent many years in private practice as well, generally I echo everything that's been said already, but it's about being on top of current affairs, as well as knowing your own field, and looking at your client's perspective all the time, and trying to bring them solutions. They don't always want an academic answer; they want a practical, commercial answer.
Okay. I'll add something from a Chambers perspective. I just Googled while my colleagues were speaking the Cambridge Business English Dictionary, and that defines commercial awareness as the knowledge of how businesses make money, what customers want, and what problems there are in a particular area of business. So from my perspective, when I was sitting where you are, and they asked us to define what commercial awareness was, and we were told when we went for pupillage interviews, this would be something that would be brought up. And so I was taught it meant about how you build a practice. Are you commercially aware enough to build a practice? Because when you apply to Chambers, you are part of a Chambers, yes, but you're a self-employed individual. And so those Chambers don't want you to be a drag, they want you to be an asset. And that means bringing in business, literally, as an individual, marketing yourself and marketing the Chambers to bring in more fees, to bring in more cases, to grow the Chambers and to make it successful. So commercial awareness for me, as a self-employed individual, is, as my colleagues have said in other contexts, being aware of what's going on, networking, we've not mentioned that, but being aware of who is around, who's instructing. In my case, I need to attract solicitors. What are they working on? What are they interested in? But it's also horizon scanning. So what could be coming down the tracks in a particular area? Yeah, in employment law, for example, we've now left the European Union. What does that mean for how businesses will be affected here? Are we going to have legislative change with the bill that's going through Parliament at the moment that's going to mean that our laws are suddenly only British? Is there work for lawyers in that field? Can we get on top of that work? When we hear that inquiries are announced by the government, as we heard about COVID or contaminated blood, are we making connections to the people who might, in the government legal department or other, have the work where they need counsel to do that? How do we get instructed on it? So it's constantly thinking, how can I bring in business to the Chambers? For me, that's what it's always meant, that you're kind of proactive. You don't just rely on clerks to get you work. You're out and about networking, you're meeting people. I'll give you an example. Last night I was speaking in Parliament because they were having an event on Windrush and the compensation scheme for the victims of the Windrush scandal. Now, by doing that and sitting on a panel with 4 MPs and a peer and lots of people in the room, lots of people ran up to me and said, oh, you're a barrister, how can we contact you? What's your Chambers link? So immediately I've made that connection, and some of that will lead to work. So for me, that's what it's always meant from a self-employed barrister perspective.
Thank you. Does anyone in the audience have a question that they would like to ask?
We're all very shy. The barristers amongst you shouldn't be shy. We're not shy, are we?
No,
We're not shy at all.
Lovely.
Not quite.
No.
I was wondering, how would you best show commercial awareness in application?
who's your question to?
Panel.
The panel, okay.
But is this for solicitor or barrister?
In any application.
Because they're different. Yeah, you do need to be aware of that. They're different. I'm trying to explain it. A barrister is nothing without good solicitors, but I've never tried to become a solicitor. I think you're looking for slightly different things. Maybe we could break it into two and explain. Maybe solicitors go first because you're the alphas and we're the betas.
Don't know about that. Everyone's an alpha.
I think the starting point would be to work on how to develop commercial awareness, because once you develop commercial awareness, it's sort of like an equation. So when you come across questions that a lot of questions on the face of them don't seem like they are testing your commercial awareness, but most of the time every question in an application is testing your commercial awareness. I can say that for at least applications for training contracts. And I would say that, again, to look at what your answers are and then analyze them in a holistic perspective. What does this mean for, it would really depend on the question, but if it's asking you to define commercial awareness, you need to understand the world that we live in today. Something can happen in one corner of the world, and it could affect economies and countries on the completely other side of the world, give rise to energy crisis, for example. And so it's important to understand, even if your question is not necessarily about commercial awareness, it's important to have that background in mind. And if you have developed the skills, it will very naturally show in your answers anyway. But also look at who you're answering that question to, who's asking the question, what firm are you applying to, what sectors do those firms work in, what kind of clients do they have, what are the current events that affect their clients and how. So try and incorporate that into your answer, and that will be a good way to demonstrate it.
Yeah, I think how to show commercial awareness is very sort of difficult, but I think it's worth breaking it down to your experience to sort of be a driving sort of vehicle to sort of exemplify how you've gained that commercial awareness. And if you have worked in a shop or as a store assistant, you're commercially aware of how business transactions, like was been mentioned, how that company is run. And I think that feeds back into the fact that you can deal with client-facing roles, you can negotiate, you can deal with a person who has a problem, a complaint, and I think a lot of value is placed on not necessarily where you're working or what you're doing, but how you can sort of weave that into your prospective applications on one side of it. And I think it's really important to sort of know, like you mentioned, the company that you're working for, they may value certain aspects of commercial awareness more than other law firms. My firm is very much like I said, quite sort of intent on making sure that there's a trusted advisor aspect to the work that we do. So I think if you've worked in customer service, you could try to use some of that experience to say that this is not going to be straight from university into a role where I'm sitting in a room with a client and I can't resonate with them at all. You've had that experience, and you can have something in common with them, and that normally breaks the ice quite well.
I was going to say, so I've sat on some interview panels for law firms before, and nobody expects a perfect answer. I mean, certainly I didn't, but we're looking for potential, we're looking for, well, it's a word again, awareness, but it depends who you're applying to. So if you're looking, or you're applying to, like a firm that does international commercial work, you would want to obviously tailor it to that firm. I'd say you need to know what's the latest sort of news in that area, the latest mergers and acquisitions, or whatever might be happening big. Read around the firm, read around the area, and then you've got to try and bring that into your application. But a point I've just made now, there's so many transferable skills. You can be working in a shop at the till, that's client facing, as you said, that interaction. You could be working, I don't know, close to do trying to think. But any job you've done, you might be volunteering at a local school or wherever you might be doing. Don't dismiss any experience you've got. It's all relevant, and the transferable skills, they all apply to law. Communication, self-confidence, all these things are things our firm will want to see, and if you can bring that out, I think that's really useful.
Yeah, I would split it. I think there's two approaches based on your stage of life. Okay, so if you're somebody who's gone into this later and you've got a career behind you, whether that's in the private sector or the charitable sector or some other sector, you will naturally have experience of that sector and you will understand it. And you can bring that to your practice as a lawyer because that's your world. So that will be authentic. For those of you who are a bit younger and have only maybe predominantly studied and you're worried, how do I prove anything? That's when you need to do exactly this and become literate by reading, broadening. You'll know about this. You need to read the newspapers, or you need to read particular trade press to your sector. Yeah, so if it's a voluntary sector, you'll be reading the Charity Times or whatever the papers are in those sectors that people in that sector read. If you're business-minded, you need to be reading the FT because it's superb. Yeah, or the Economist that's weekly, and then you're always up on what's going on. If you're a student, so at least it means you've got some fluency, even if they say, well, you know, have you had a job in it? But if you can show that confidence, and that is part of being a lawyer, we bluff quite a lot. Yeah, we read things very quickly, and then we have to, if you're a barrister, regurgitate it back out and make it sound like it's the only case you've ever done, and this is the case of your life, right? That's what they think. You know it's not, but you need to be able to do that. Yeah, and so I would call it being sophisticated. You've got to watch the news, you've got to read the papers, you need to be aware of the world and the sectors you're in. So if you're young and you've not had a job, you can still show potential by showing you're aware of things and being a bit sophisticated. That's the word I would use. Boston.
I would just add a bit more on sort of ways you can demonstrate commercial awareness when you're filling in, let's say if you want to come to the bar and you're filling in your application for pupillage, for example, and that's quite typically done through what we call the pupillage gateway, which is a set sort of application form. You can apply to at least 10 sets of chambers, and you fill in these sort of standard questions. Normally what you will see in this sort of form, and even if you apply to chambers which are outside the gateway system, there's still a sort of similar structure of the form, is that you'll see like a section on your experiences in your CV, and then there's a section on questions which they will specifically ask you about why you want to become a barrister, for example, which area of practice you want to go into, perhaps name a case which you are particularly interested in or might have caught your attention within a chamber's area of practice, and you have to explain why. So let's divide those sort of two. So starting first with the CV side of things, I can probably endorse everything that other panelists have already said about, you know, having your experiences and all of that. I would say just think laterally about sort of your experiences and the sorts of things that you sign up to. Don't just think that, well, I'm not becoming a solicitor, so why get into sort of anything related to corporate work, for example? Because I remember, for instance, when I was at King's, I did a commercial awareness competition with one of the sort of leading law firms around in London, and it was about sort of putting together a pitch for a client on a corporate transaction, and that actually was quite an interesting experience because it was something which I wouldn't have otherwise known about in terms of, you know, developing your practice, thinking about what your clients want out of you as a service provider, things like that. And that actually was, you know, something which interview panels, even in chambers, picked up on when I was going into interviews. So don't just confine yourself to particular things which you think are specifically related to areas of practice that you're going to go into. Just try everything, I think is the main sort of advice I would give you. But even going beyond that, perhaps think a bit more, if you're wanting to go down the route of the bar, think about the sort of practical legal experience you can get. And I'm talking about, you know, going beyond mooting. So for instance, you know, get involved in a law clinic, do pro bono work. You might think, well, that has nothing to do with commercial awareness. But quite the contrary, actually. When you think about commercial awareness, it's really just about practical real-life experience with clients, not just things you read on the textbooks. So doing any sort of pro bono work, you know, be it the free representation unit, if you're in the employment tribunals, you know, great, you know, you'll be asked about it, people will be interested. I remember when I was at City, for example, I did a bit of housing work down in Wilson County Court. Nothing to do with what I'm doing today. But when I walked into Atkin Chambers for a pupillage interview, the first thing they asked was, oh, so what is this about? How did you advise your clients when you were in court? What sort of commercial considerations you took into account when, dealing with rent arrears, for example. So things like that, practical legal experience, I would say, is very crucial. So think about that and just grasp every opportunity you can. And I would say just generally, if you're doing any sort of legal experience, many pupillages, training contracts, think about the commercial awareness that you're gaining through that process and make sure that you're ready to explain it when you're in your applications or in your interviews. And then just very briefly, sort of moving from the CV down to sort of the questions you get asked in a pupillage application form. You always get asked, why do you want to become a barrister? Which area of practice you want to go into? And I think the long and the short of it is, make sure when you're answering these questions, you can show that you are sort of demonstrating a bit of commercial awareness. So if you say, why do you make a good barrister? Why would you make a good barrister? Perhaps think of your qualities, in terms of commercial awareness, what sort of commercial skills you've demonstrated before through experiences, and weave that into your answer. Similarly, in terms of the area of practice, think about the commercial realities of the practice you're going into. So if you want to go into commercial disputes, think about, well, why is it interesting to you? Because there are complex contractual mechanisms in a very particular commercial context, but with very sort of complex sort of financial considerations, for example. If that's the sort of thing that sort of engages you, then say it and make sure that it comes through and comes across that you're thinking not so much just about the law, but about how practical disputes sort of play out in the commercial industry. So I think, weave that all into your answer, and, with a good CV, that will sort of stand you in good stead, I think.
I'd just like to add something. When it comes to commercial awareness for me, one very good starting point for me was to understand the foundation of the commercial world, and that's something that you could get from books, whereas the current events and analysing current events, that's something you'll have to build over time. But one very good starting point would be to pick up a book on Introduction to Commercial Awareness, or a starting point, so that when you come to reading the Financial Times, when you come to reading news articles and trying to understand how that could affect certain sectors and certain clients, it contextualizes everything for you. A very good book that I read was Introduction to Commercial Awareness by Christopher Stokes. It was a very, very short, very brief introduction, but it was a very good starting point. So I just wanted to add that. I think that would be very beneficial.
Well, that's a very good question, actually, and I think it sort of probably applies generally to any area of dispute resolution, not just sort of my area of practice. But certainly, particularly for commercial disputes, ADR is becoming increasingly important. You don't probably get very much exposure to ADR when you're in sort of your LLB stage, or even probably at your GDL stage, but you will have a module solely on ADR when you get to the bar course, because that is one of the modules you'll be examined on. But if you want to really get ready for that and sort of think ahead whilst you're in your LLB stage, then certainly I think thinking about how different forms of dispute resolution plays out in reality and why different people would choose different ways of dispute resolution, thinking about the commercial factors which might drive or motivate each choice, that would be very important. There are actually quite a few events which are sort of around ADR, even for students. So, for example, there is, I think CEDA organises a negotiation competition every year, for example, and basically you get teams of students from different universities. They will be given a brief, and then you will have to negotiate your way through that particular brief, and you'll be sort of judged on that basis. So that is a very good example of something which you can, as a student, even as an LLB student, get involved in and show that you're thinking about ADR and the commercial realities behind the sort of ADR process. And I think probably ADR is one of the best examples of how commercial awareness feeds into dispute resolution, because when you go into litigation arbitration, quite often you think, well, it's always about the legal, factual merits. But when it comes to ADR, it's really very much less so about that. It's about, trying to reach an amicable settlement, trying to keep it out of the public eye, for example, without having to go through the expense of the courts. So thinking about how mediation, negotiation, what are the benefits of that would be very helpful. And if you can actually weave that sort of experience into your application, for example, or into your interview answers, then all the better, because I think these days as a commercial barrister, I can tell you, probably 9 out of 10 cases settle out of court.
Yes.
They might not even go to arbitration. I mean, arbitration is already an ADR itself, but most people settle even outside of arbitration hearings. So, the hearings we actually get are very few, and most of the work that you do will be advising on, let's say, leading up to a mediation, what are the prospects of success, what is your best case scenario in terms of a settlement and things like that. And that just sort of amplifies the importance of commercial awareness in ADR if you are even going into the bar.
Can I add to that? Just to add to that, also in civil areas of practice these days, areas that don't appear to be commercial as such, so employment law, there is a big move towards judicial mediation.
Yep.
So, traditionally you'd have a worker, the employer, and they'd get into the tribunal and they'd have their 5-day hearing or 6-day hearing. These days, at a very early stage, judges and the actual form, the claim form for claimants, is encouraging people to go to judicial mediation. And the judges absolutely love it, okay? Because they're there, they run, both parties are in 2 separate rooms, the judges run between them, and normally the businesses want to do that, exactly as you say, to keep it out of the public eye, because now every single employment tribunal judgment is published online. So even if you as the employer think, well, we're not in the wrong, but you might have another motivation. So even now increasingly, and family as well, they're moving towards kind of mediation. So commercial awareness for those is not even just about commercial transactions. A lot of civil law now and civil areas of practice are increasingly want to go to mediation, some form of ADR to settle. So think about that. You can introduce that when you're asked in your interviews about, well, what do you think is going on, with ADR? It's not just commercial anymore. It's now moving into, and these are, some of these are family law. A lot of it's legal aid, employment law. These are litigants in person, some of them, but increasingly judges like it, and you do get a settlement, and that's what everybody wants, to just not have the stress, not have the bad publicity, etc. But employment law is definitely a growing area, and that's what I mean. If you're reading up around what's going on, you'll find out this stuff. Sign up to bulletins, and as many as you can. I still get the Law Society Gazette every day coming in, things like that. So you've got the brief on a Thursday from the Times. They give you a nice rundown and synopsis of things that are going on.
Thank you. Are there any more questions? Yes, please. Will you say who your question's for?
It's for the panel, because we are talking about alternative dispute resolution, and I'm studying commercial dispute resolution in the LPC right now. So I'd like to ask about, when we talk about alternative dispute resolution, in terms of when we talk about commercial awareness, how we come into play with how we apply in commercial awareness, to my understanding, is to stand in the client's shoes and to calculate their risks. And because going to litigation is a huge cost. So do you think that when we talk about commercial awareness, we'll try to minimize the cost for the clients, and how does it work, and how does it work in actual practice in this case?
Right, I'll try to make a start on that. So, I mean, it can work in various different ways depending on the clients you're advising, really. It's a very lawyer answer, but so it depends. But essentially, I think what you start off thinking is, first of all, in a way, alternative dispute resolution is a bit of a misnomer, because it shouldn't be alternative in many ways. I think, as Miranda's very rightly put it, it's almost sort of encouraged by the court or even by arbitral tribunals these days as the primary sort of form of resolution you should think about first before incurring the cost and the time of going all the way through to a trial in court or an arbitration hearing. So almost, I think the first thing you think about when you get a case, whether you're a solicitor or a barrister, doesn't quite matter, is to think about the possibilities of settling it, or potentially finding some form of other sort of arrangement where you don't have to go all the way to court. And most clients actually come to you with that in mind, even if they don't say so expressly, because, first of all, for any clients really, money is always a bit tight. Costs is exactly. It's just you don't want to incur costs unless absolutely necessary. So even if they don't ask you the question, you as a good sort of practitioner, barrister, solicitor, advising a client, you should always sort of have other alternative means of dispute resolution in mind in the first place. So you use that as a starting point, and you think about, well, okay, look at the merits of the case. Does it look like, looking at the dynamics between the parties, the sort of, let's say, the sort of commercial relationship they have, the level of mistrust maybe, or maybe the level of potential for future cooperation in other projects. You think about whether there is any prospect of a settlement, because that really is the driver behind a lot of sort of the effectiveness of ADR. If the parties are not really sort of getting along very well, probably they'll just fight all the way through for no good reason. You can still advise them to settle, but you should bear that in mind. But on the other hand, if you feel like, well, there is a commercial relationship there, which obviously both parties want to maintain, then all the more reason you should think about, well, encouraging your clients to sort of reach out to the other side, or if the other side reaches out, then you encourage your client to accept that sort of offer, to just sit down and maybe have an amicable chat, whether it's a negotiation or mediation, doesn't quite matter. So that's the sort of process you start off with, and then when you're advising on the merits, then you start thinking, okay, well, what is the sort of best case scenario in terms of, well, okay, quantum-wise, how much do you think the client is likely to be entitled to as a sort of, even as a ballpark estimate? What are the sort of key strengths and weaknesses legally and evidentially? And then you tell the client, look, you want to frame this case in this way so that you put your best foot forward when negotiating with the other side, but also sort of with sort of quite a realistic expectation of what might or might not work. And then hopefully, you sort of move into a negotiation and mediation in sort of the best possible position and try to reach some form of middle ground between the parties. And that's the sort of thing you should always be thinking about when trying to frame your case and advising your client in the first place. And obviously, when you think about sort of costs and all that, that is also quite important, because that would also feed into the sort of, let's say, the settlement offer you would want to put forward, or when you want to put forward your settlement offer, things like that, which are also quite crucial, because more often than not, when you're asked to advise on a case, you're not just asked to advise on the merits, you're also you're advising on a strategy. When do you want to put a settlement offer forward? What form of settlement offer do you want to put forward? Do you want it to be a Part 36 offer where there will be cost sanctions involved if you don't accept or don't beat the offer? Or do you want to put in just a WP without prejudice offer where it's sort of open-ended, open for acceptance, but would be relevant if, let's say, you win a trial later on if the other side refuses. So I would say that's a sort of considerations that I would have to think about when I'm asked to advise on a case, or in every case, in fact. And then finally, just one brief point I would say is just to bear in mind also that, if you're dealing with international clients, then there may be also particular concerns that they have, for example, even sometimes dealing with geopolitics. So if you're dealing with an Asian client, they might not want to be in a particular forum, they might not want certain news to come out in the public, or they might not even want certain arbitral tribunals. Or certain members to be arbitral tribunals because they feel like, oh, well, nationality is a concern or language is a concern. So that's, again, something that you should always bear in mind when thinking about ADR, I think, from a commercial disputes perspective.
One more thing. Another thing that you need to be doing as a lawyer, especially when you're advising on like ADR, you need to give your clients a reality check, okay? Because some clients come and they're really gung-ho and, they've somehow got all the way, if they've got to a barrister, they may have fantastic solicitors who say, look, we really think you should settle, they've looked at it, they just don't listen, right? Especially the clients who are wealthier, powerful, they're the captains of their industry. They know nothing about law, but because they're so successful in their area, they think they know it all. So sometimes, this is speaking to the future barristers among you, your purpose is to kind of tell them what the solicitors told them, but they haven't been listening, okay? And to really be brutal and blunt with them about costs, about, listen, what are you doing? Because it's in their best, it's tough love. And I had that actually in an employment case. So I had a claimant who put in, by herself, a claim form with about 10 different heads of claim. Everything was in there. Unfair dismissal, discrimination on 4 areas. Religious, race, you name it, whistleblowing, victimising, everything was in there. She drove the solicitors crazy. By the time it got to me, and I met her and I said, take that out. You've got no cause of action, out. Let's get you to judicial mediation, because you will be destroyed in court, you don't normally get costs against you in the employment tribunal, but it happens. to send a message to claimants to not bring spurious claims. So sometimes it's also about tough love when you're pushing them that way, because it's better that they get a small sum in a mediation with no costs than, I want my day in court. No, you don't. Sometimes stopping them going into court is in their best interest commercially or financially. Does that make sense? Yeah, you have to be tough love. Bad cop, good cop with your solicitor. They're good cop, the alphas, we're the betas, the bad cop. Yeah?
Just one small point about your day in court. It doesn't exist.
Exactly. Because the thing is, you don't know what judge you're going to get. That's a lottery. It's a lottery. You don't want to go there, Good judges might be in a bad mood, and then, it's a disaster.
Yeah, I think I would just add, I feel like ADR is like a game of poker, and commercial awareness is being able to see the other opponent's hands. That gives you that ability to sort of see through them, and I think to some extent gives you an edge to win the case. And it's not always about winning, but getting the right outcome for your client.
Thank you very much. I think we might finish the formal part of this evening now. There are drinks outside, and are the speakers happy to speak more informally? That would be lovely. And there's a QR jiggery for you to photograph and scan, if you like. And thank you very much to everyone for coming on this very wet evening. It was really interesting, and I'm sure the students benefited greatly from your insights into the profession and into this difficult subject of commercial awareness. Perhaps we'd all like to show our appreciation.